In this video, we're talking about how lawyers are plagued by the curse of knowledge. Bum, bum, bum. I know, curse of knowledge sounds super scary, and that's because it is. So let's do a bit of an experiment before we get into the analysis that is the curse of knowledge. The experiment's real simple. I'm going to tap a song, a very short song, on this book so you can hear it. It's your job as the viewer to figure out which song I'm tapping. And if you don't want to cheat, go in the comments. Don't read any of the comments that may be ahead of yours. Type in the song that you think I'm tapping, and let's see if you're right. Victor, my editor who's watching this, no cheating either. I want you, after I play and tap away, to put the song that you think it is at the bottom of this video in this little area in order to make your guess as well. And again, Victor, don't cheat. If you're right, you're right. If you're wrong, let's see how wrong you are. Okay, no pressure. Let's see if I can have my rhythm. What's the song? Put your answers down below. Victor, you know where to put it as well. Let's see if you're right. So if you guessed Call Me Maybe by Carly Rae Jepsen, you're wrong.
Hey, I just met you, and this is crazy, but here's my number, so call me maybe.
That is a very catchy tune though, and I wish I could tap to it, but I ended up tapping Happy Birthday because I was hoping it'd be the most universally known song to tap to. But I'm curious, how many people actually got that right? And the reason why I bring this up is because in this book that I'm reading, Made to Stick, I just started reading it, so I'm not going to do a full book review, but the beginning of the book talks about an experiment very similar to what I ended up illustrating for you, where you had tappers and you had listeners. And tappers had the ability to tap to 120 songs, and then the listeners had to guess which song out of that 120 was which. Could they name the 120 songs that were being tapped to? The results ended up being very interesting, and from a lawyer's perspective, very scary, to where I didn't even bother to finish reading this book to share this experiment with you. So I want to share the example coming out of Made to Stick, and I'll go ahead and provide a link to the book down below. So in this 1990 experiment, there were 120 songs, like I said. You have your tappers, that was me in this situation. You have your listeners, that's you in this situation. Over the course of 120 songs tapped to, the listeners, you in this situation, only guessed 2.5% correctly. Meaning they only got 3 out of the 120 songs. That's not what's concerning from a lawyer's perspective. What's concerning is that before the listeners guessed the name of the song, the tappers were asked to predict the odds that the listeners would guess correctly. The tappers predicted that the odds would be 50%. Now this takes us to the curse of knowledge. Bum, bum, bum. So on one hand, you have tappers who can basically hear the song as they're tapping to it, to where they are like, well, this is fairly easy. I'm guessing half the time the listeners are going to be able to get this right, because isn't it obvious as the tapper can hear the song that they're tapping to, but the listener has no idea, has no context, and is having to come into the situation listening to that tap cold. And 2.5% of the time, the listener was correct. 97.5% of the time, listener was wrong. I hope that math's correct. Here's what the book says. It's hard to be a tapper. This is me in this situation. It's hard to be a tapper. The problem is that tappers have been given knowledge, the song title, like Happy Birthday, that makes it impossible for them to imagine what it's like to lack that knowledge. When they're tapping, they can't imagine what it's like for the listeners to hear isolated taps rather than a song, basically hearing Morse code. This is the curse of knowledge. Once we know something, we find it hard to imagine what it was like not to know it. Our knowledge has cursed us, and it becomes difficult for us to share our knowledge with others because we can't readily recreate our listener's state of mind. From a plaintiff lawyer's perspective, this scares me to the nth degree, because if you were to ask me as a plaintiff's lawyer what percentage of jurors I need to understand the information I'm trying to convey to them, my answer isn't 50% like the tappers. My answer is I need 100% of these jurors understanding exactly what I'm saying. I have no margin for error because my client has the burden of proof in order to win the case. But then the question is, how is the curse of knowledge plaguing me? I've gone to law school. I've been doing plaintiff's work my entire career. I use the word preponderance on a regular basis. I use proximate cause on a regular basis. I use foreseeability on a regular basis. Most likely, the jurors that are listening to a case have probably either never heard the word preponderance, or two, which I can guarantee this, have never used the word preponderance unless you somehow have a plaintiff's lawyer or a defense lawyer sitting in the jury box, which is very unlikely. So you start trying to unravel the complexities of this curse of knowledge, and you realize that it's multifaceted, to where not only is it the legal jargon that you're having to try and teach to a jury, but you're also, legal jargon aside, trying to teach legal concepts, injuries, and client perspective. For example, with client perspective, I've been talking to the client leading up to trial, maybe months, maybe years. And so I have the knowledge of what the client has gone through. And what I've learned is the client suffers to some degree the curse of knowledge because I have to start pulling that pain and suffering story out, the mental anguish story out, a little bit more than what people are used to just telling in a casual conversation. It takes sometimes pretty pinpoint questioning of my own client during a one-on-one phone call to be able to get the full depth of their story. And so I then have to basically play a telephone game with the curse of knowledge to then bring that information out during the course of a trial for it to ultimately resonate and be internalized from the jury's perspective. Here's an extreme example, and this is outside of just like client interaction. When I went to this last and most recent Mark Lanier Trial Academy, by the way, I have an interview with Mark Lanier that I'll slide a link above so you can check it out. We talk a little bit about his Trial Academy. He has it every year. If you're interested in checking out the Trial Academy or his Trial Academy, check out that video, get a sense of it, and then there's a link in that video that'll take you to his Trial Academy sales page. It's not a pitch, it's for charity, so I'm always very open with trying to promote his Trial Academy because not only is it for charity, but it benefits the plaintiff lawyers that go. Over 1,000 end up going, so there's a lot of people that are benefiting. That aside, at this last Trial Academy, Mark ended up telling a story where he ended up winning a trial for a reason he wasn't anticipating, or at least a large reason for what he wasn't anticipating, because he, after the trial, went up to the jurors to get their insight. What were they thinking? What was their perspective? And the thing that's really stuck out to him was that the jury was like, man, the other side, the witness they called just hurt them. Like that witness was not helpful. And as soon as we saw that, we knew that their case wasn't any good. And the way Mark tells the story is internally, he was thinking, yeah, they called an adverse witness. So that's why it wasn't necessarily too helpful and friendly for the side that called that adverse witness. And so let's pause. Let's think about that. From a lawyer's perspective, especially if you have your witness designation list, you're taking a look at the witness list and you're like, all right, I think that's an adverse witness. I understand that. The judge understands that. The other side that's calling the adverse witness understands that. But we sometimes overlook the fact that the jury has no idea that the person going up there is for the other side. So that's something that you just almost assume, like you forget that from the perspective of the jury, that that's not clear to them. And that's just a procedural issue. That's not even getting into the actual facts, legalities, legal concepts that you also want the jury to grasp. So that's scary. That's a scary concept because you then have to start analyzing everything from a lawyer's perspective of, okay, if I knew nothing, then what do I need to teach a juror in order to convey the message, tell the story that I want to ultimately teach and tell to that jury? And then that leads to a lot of more questions of not only what am I having to teach, but how am I going to teach it in an effective manner? From a lawyer's perspective, you also need to keep in mind the practical fact that you can't boil everything down to the basics in order to teach anything and everything during the course of a trial, because you do not have infinite time during the trial. So that means you need to, before trial happens, figure out which concepts, whether it's a legal concept, an injury concept, or like some type of core understanding or belief or principle in your case, needs to be taught and addressed as like a priority hierarchy. And then in doing so, you need to figure out not only which is going to be the priority, but how am I going to teach this in a way that makes sense for somebody who has no experience with law? That's tough. That's really tough. That's why I'm reading the book Made to Stick, in order to have concepts stick with people and in order to simplify those concepts so they do stick in a compelling way. Haven't finished reading the book. Once I do, there will be a follow-up review to the entire book as a whole. But as of right now, let's keep looking at it from the lens of a lawyer. If you're trying to figure out what the concepts are going to be and how you're going to teach it, you need information. You don't want to make assumptions, because like the tappers that were making assumptions that 50% of people would understand and ended up being 2.5%. You don't want to risk that. Don't make assumptions. Get data. And in order to get that data, you need a focus group. But I'm going to say focus group a little bit more loosely than probably what your immediate connection is. If it's in the budget and you're able to pay for having a legit focus group, then by all means, go for it, right? It's in the budget. You're going to benefit from it. I think you're very rarely going to walk away from a focus group being like, that was a waste of time. Go do it. But if you're balling on a budget with a little bit of a tighter budget, then you need to be talking to your friends and family who have no overlap at all with lawyers, law, and your case to any degree. If their significant other is a lawyer, I wouldn't even really bother. I mean, if you wanted to get the data point, go ahead. But I would talk to people who are as green as can be, because not only do you want to see if the way you talk about the case and the legal concepts causes their eyes to glaze over, but you also want to get, and this is probably the most important part, you want to get their questions, right? And you want to get their reactions. Whoa, so-and-so did what now? And if they're getting engaged, then you know, okay, that's a juicy part of the story. And here's a big takeaway. If you're telling somebody who's totally green to the law and has no like interaction with any legal concepts on a regular basis, if you're telling them the drama of your case and they are not just like super focused on that story, if their eyes glaze over and they're just not into it, that's a you thing. Like that's not a them thing, because the people over the many years that I've been either a law student or a lawyer, when I tell those people like, hey, here's what's going on behind the scenes involving the wheels of justice, they're into it. They want to hear the juicy gossip involving the story. They want to hear the fights and the struggles, and they want to kind of start casting their own judgment based on what they're hearing from you. And if they're not into it, that's probably either your delivery or the way you're teaching isn't making sense, or you're just not positioning the case in an optimal way for it to be the best, most engaging kind of story that you're trying to tell. That's important data. Like, if anything, you want to bore some people to see, okay, what is either causing them to snooze, and then can I throw in an extra detail that causes them to wake up? All of that will help give you great perspective, because you don't want to gamble with 50% of the listeners understanding the taps. If you have the burden of proof from the plaintiff's perspective, you want that to be 100%. But you also got to figure out, on an efficiency standpoint, where do you need to go into the weeds? And then not only go into the weeds, teach it in a simple and compelling way so that's internalized with the jury. Because at the end of the day, when they make their decision behind closed doors, you want that concept to be prevailing in their minds and their hearts so that they can rule in your client's favor. And if it's not taught in a compelling way that they understand with their everyday lives and concepts that they see on a daily basis, then it's going to fall flat. And even if it does go in your favor, it probably won't go in the favor to the degree that you want it to go in your favor. So it's all about talking to people. More importantly, talking to non-lawyers to figure out where the curse of knowledge is plaguing you so that you can get the information to help offset the curse of knowledge. So the gift of knowledge is that you need to have more friends, and you need to support the people around you and talk to the people that are in your lives. Yeah, that was a little bit of a off-topic proverb of some sort, but I hope this gives you some perspective. I really just I want to caution a lot of people that are probably like, I get it, I understand, I need to simplify the case, it needs to be in a compelling way, but you're only going to get that data from talking to people. At the end of the day, you're only going to figure out what is important by talking to people. I would even take it a step further and talk to other lawyers as well, in the context of seeing the data point with Mark Lanier. I never would have thought about the whole adverse witness thing backfiring on someone, and that being a concern that if I'm calling somebody as an adverse witness, that may negatively affect my client. So talk to lawyers, because they are probably hopefully doing focus groups or getting experience that you feel like could be beneficial to you. It's all about sharing information. It's all about growing together, which means I'm going to pitch. If you're a plaintiff's lawyer who wants to join the Law of Entry community, which is free to do so, I'll provide a link down in the description so that you can come join us. You can come pose any questions that you have, provide any tidbits of information that you'd like to provide, and help kind of grow that network of plaintiff lawyers that I think could benefit everyone. So if you have any questions, let me know. Full book review coming out. Link to the book if you want to not wait for the full review, because no telling when it'll come out. I'll provide that link down in the description. With all that said, I'll see you in the next video. You have a good one.